Record. Hi, good morning, Anthony. How are you?
Hi, good morning, Arianne. How you doing?
I'm good, thank you. I'm super excited to talk today about, this employment agreement. Dr. Rhodes is really excited to start talking about working with Ascendia and stepping into this new role.
Yeah, definitely. I mean, we're excited from our experience in the biotech space, and we're excited to get things going. So, I mean, if
Awesome.
you want to start off with the negotiation, asking a couple questions.
Yeah, I think the biggest, question and probably what makes the most sense to start with is compensation and equity, if you're okay with that.
Right, completely agree. Yeah.
So I wanted to ask you, what is the budgeted salary for this position?
Yeah, so really our range is from 300K to 325K. And really at Ascendi, we prefer to deliver additional upside through performance-based components rather than just straight cash.
Okay, so what Dr. Rhodes is looking at right now would be a 340K base, which is pretty much market rate for a CEO at a Series A company, especially one with, $20 million in funding in the AI and digital space. We do feel like this is fair based on, her rare contributions. She has a PhD in cognitive neuroscience. She has CEO level operational experience and regulatory compliance.
Okay. I mean, r really for us, we do believe that 325K is extremely fair, especially because we're just starting global expansion. We understand and we respect her credentials, and I think we could reach a target point of 325K and then talk about performance-based bonuses.
Okay, would you all be okay with 330K potentially?
I think really 325 is the highest
Okay,
for
we can
now.
do 325 and then maybe talk a little bit more about equity and how can she can make some of that money up in terms of equity, if that's okay with you.
Yeah, definitely, of course.
Okay, perfect. Okay, so then we're good there. We can chat a little bit about equity. So
Mhm.
how would the equity pool be structured post Series A? Percentage is typically allocated to the CEO role.
Yeah, so post Series A, our equity pool is really whatever is operated in the equity plan. So the initial grant would be calibrated to the stage that we're in. So usually we're looking at low to mid single digits, maybe 3 to 6%. With I saw in the negotiation proposal we would have the 4 year vesting and the 1 year cliff we could get into. But yeah, it's gonna be finalized against the equity plan.
Okay. So let me just, look at my notes really quickly and see kind of what Dr. Rhodes is looking for in terms of the equity. And do you want to, can we review the actual equity plan once before we talk a little bit about what she's looking for?
Yeah, of course. We'll provide the plan and any other related agreements, and then the
Okay.
equity terms are going to conform to it, of course. We want to build that trust between us as well.
Okay, yeah, that's awesome. Can you also walk me through like the vesting schedule and kind of what happens to uninvested equity in different termination scenarios?
Yeah, definitely. So as far as the vesting schedule, we're okay with the 4 year vesting with a 1 year cliff. So she'll get the 25% after the first year, and then in equal monthly increments thereafter. And
Okay.
then we need acceleration for the equity vesting to only happen upon change of control and involuntary termination. So
Okay.
I could run through the different scenarios here for you for unvested equity.
Yeah, we can talk to that.
So for termination for cause, the unvested equity would forfeit. There would be no acceleration. For termination without cause, same, unless there's a double trigger of change in control and involuntary termination. As far as resignation for good reason, we wouldn't have acceleration by default. Similarly, if we can define good reason as involuntary termination for change of control purposes, and it occurs within the change of control window, then the double trigger would apply. For voluntary resignation with no good reason, unvested would be forfeited. And then for death or disability, there wouldn't be any automatic acceleration, but any relief could be at board discretion, but we could obviously agree to the terms beforehand. So it's not.
Okay. Yeah, we could talk a little bit more about the specifics. It's really good to hear those. I just wanted to talk a little bit about um, what Dr. Rhodes is seeing in terms, especially kind of making up some of that base salary. And,
Mhm.
she did kind of request higher, but I totally understand the position you all are in.
Right.
So really appreciate the transparency on the equity structure, and I agree that working within the approved equity plan is the right framework, but I did want to propose some specific terms. So our equity request would be 2.5% ownership, a 4-year vesting schedule, and a 1-year cliff. Totally get that low to mid single digits is reasonable for like a typical Series A CEO, but our situation kind of does differ a bit materially. So, Dr. Rhodes is joining already with 200 million already raised, product market fit established,
Mhm.
and enterprise clients secured. So she is really looking for that 2.5% ownership in the 4-year vesting schedule.
Yeah, we're completely okay with the 2.5.
Okay, perfect. Yeah, that's okay. Perfect. And then I did want to talk a little bit about, so yeah, I know you talked me through the proposals for the unvested equity in each scenario.
Mhm.
We can maybe talk, if we could just talk about good reason later, since we're both okay with the vesting schedule and the 4 years, and that she'll get the 25% after each year and the 2.5% ownership. So we're good with that. That's perfect and kind of making up some of that base salary.
Mhm.
Um, Let's see what else we have here. Does is there like really any other questions that you would like to ask me about compensation and equity? I think in terms of mine, I think Dr. Rhodes is, good with the 350K as long as she gets the 4-year vesting and the 2.5 ownership with that 1-year cliff.
Okay. Yeah, I mean, I think we did go over a lot of things I wanted to talk about,
Okay, perfect.
but since we already contemplated on salary, let me see what other questions I may have that are different.
Yeah, if there's anything else you want to talk about salary, if not, I'm good to maybe talk a little bit about the board seat and governance, and then we can put a pin in good reason for now and chat about that later.
Yeah, I think just as far as compensation, I think the only thing I have, and maybe a little different from what we talked about,
Mhm.
is whether Dr. Moore would be able to agree to a 3-month minimum clawback trigger for the signing bonus.
Yeah, we would definitely think 3 months is a little too short. The clawback we would say should be 12 months minimum.
Okay. As far as club, okay. Yeah, we're okay with that as well.
Okay,
And
perfect.
we appreciate the dedication from
Yes.
Dr.
No,
Moore.
we really appreciate y'all. Okay. Do you want to talk a little bit about board seat and governance?
Yes, let's talk about that.
Okay. I can ask you just because obviously you all are the one with the board, so just so Dr. Rhodes can, understand a little better and we can take this information back to her.
I'm
Could you
sorry, before we go,
go
I'm
ahead?
sorry, I just have one quick point
Yeah, of
I want
course.
to add. As far as compensation, is she okay with a double trigger acceleration? So only upon both a change in control and involuntary termination?
So the double trickle on change of control is fine. We're not asking for automatic vesting just because there's an acquisition, but we would like to distinguish between two scenarios. So if there is a change in control, double triple is totally acceptable. Only if there's a change in control or, Dr. Rhodes is terminated or constructively terminated. But with termination without cause, we would need a single trigger acceleration. So if you all terminate Dr. Rhodes without cause, um, yeah, we would like that single trigger acceleration.
Okay. The only thing is we would need it to accelerate only if it's change of control and involuntary termination. So we would need double trigger for both.
Okay. Yeah, the issue I guess is more is if she is terminated without cause, but I think we would be okay with that.
Yeah, I think we could definitely counterbalance on that.
Okay.
Yeah, I think we're good with moving on to the board seat if you
Okay,
want.
great. Could you just describe a little bit about the board's composition and, decision-making structure?
Yeah, so the board in Ascendia is currently composed of 5 members,
Okay.
and decisions are based on a majority vote. So when all members that are likely going to be present at these board meetings, they really care about the business. We're not going to experience any deadlock, so there's no worry there.
Okay, great. And how does the CEO typically interact with the board chair, versus like the full board?
Right. So here, Dr. Morgan would be able to report to the whole board, not directly to the board chair, just for individual personalities, really just reporting solely to the board. And then the chair would just coordinate the business of the board, and then performance reviews are conducted by the board. But Yeah, she would report to the board in general.
Okay, and what would the board's philosophy on CEO autonomy for operational decisions versus strategic decisions look like?
Yeah, so day-to-day operations are would be totally within Dr. Morgan's control. It
Okay,
would
perfect.
just, as long as it's within the budget approved by the board. As
Okay.
far as C-suite hiring, major contracts above a certain threshold, that we could talk about the number later in the contract, perhaps million. And then any M&As would require prior board approval.
Okay, yeah, for M&As, we're totally okay with that, and I'm good with having a certain threshold for the contracts.
Mhm.
And then what does the regular, governance cadence look like? How often is the board typically meeting?
Yeah, so typically the board meets on regularly scheduled biweekly meetings.
Okay.
There are a few additional special meetings that will obviously include limits on the contract, and we'll circulate the annual calendar before execution, so we have expectations that are clear.
Okay, great. I mean, that's just kind of to get a little overview for her and bring it back
Mhm.
to what, her relationship with the board would look like. So if you want to ask me anything else about a little bit more specifics about the board, you can go
Yeah.
ahead.
So would Dr. Morgan accept board attendance rights or just like an observer role instead of voting membership, at least for the first 12 months of employment?
Honestly, no. The observer seat is really not going to work for her, not even for 12 months. She really strongly feels like the CEO needs a voting seat from day one, for strategic decision making, fiduciary responsibility. That's kind of the market standard is for her to have a board seat from day one. And even if it's a kind of a let's see what she does, like we feel that that's, the wrong framing. She really wants to be fully integrated and involved.
Right, and I mean we completely respect her credentials and we trust that she'll do a great job. So yeah, I think we can concede on that point.
Okay, great. Perfect.
As far as if a board seat is granted, I guess instantly, can it be reviewed annually by the board based on performance and alignment with Ascendia's vision?
Like I said again, Dr. Rhodes really wants to be integrated. We don't feel like it would be fair to have this structure, but we are totally okay with evaluating her performance annually, and we do understand there's gonna be a remedy for poor performance, and we can kind of talk a little bit more about that, but we would like that not to be tied to her board seat, rather what her performance is, if it gets to the point where it's like her performance is so poor, there's termination,
Mhm.
but definitely not to take away her board seat.
Okay. Yeah, and I mean, I think we talked about the operational autonomy subject to board budgets and then board approval for any major contracts or
Yeah,
M&A.
we're
So I,
totally okay with that, and we know that for board approval for major contracts and board approval for M&A is pretty standard for the market. So,
yeah, awesome. So yeah, we could go into termination if you want to start.
okay. So what would constitute cause for termination in you all's view?
Yeah, so for us, really cause is going to include willful misconduct, policy breach, breach of fiduciary duty, fraud, or consistent performance failure after notice and cure. And obviously, we'll outline this in the contract and we'll be able to really
Mhm.
hound down on the definition so we have a clear understanding between us and
Okay.
just reduce any potential disputes that we may have.
So would you all be expecting a release of claims as a condition for severance, and what claims would be, released versus preserved?
Yeah, so severance is would be conditioned on a standard total release of employment related claims. If there's no release, there's no severance. So it's just a basic risk control that we have to have at Ascendia.
Okay, got it.
Yeah.
So, and have you had any situations before where previous executives were terminated? How did you all handle that?
We have, but really our philosophy is just balancing protection and investor discipline and also respecting the skills of our employees. So we would have reasonable cash severance, as outlined in any contracts. And yeah, and we've dealt with it amicably generally with our employees.
Great. And then I did want to ask you too, like what happens to an invested equity if Dr. Rhodes would be terminated without cause?
Yeah, so I mean the uninvested equity would be forfeited. I mean, unless obviously the acceleration of the double trigger would be met, so the change in control and involuntary termination. But yeah, otherwise it's forfeited.
Okay. I think maybe we should talk a little bit more about all of those things, but if you have any other questions for me, you can go ahead and then we can kind of meet in the middle on, some of the.
Yeah, I guess just generally to have a good understanding of where this relationship is going,
Mhm.
what is exactly Dr. Morgan's vision for her role and her scope of responsibilities within Ascendia?
Yeah, she definitely envisions a full scope CEO role. So, like strategic leadership, helping to set company vision and strategy with board partnership, leading fundraising, Serious B and beyond, major, M&A and business development, regulatory navigation. She does want to build and manage her own executive team. She wants to, have product roadmap, go to market and financial management, scale operations, and help with the culture. She totally understands that she's reporting to the full board. And she's, like I said before, we're totally okay with that contract cap of board approval. We're totally okay with board approval for M&A. Um, Something she doesn't envision, which I think would be maybe a little more helpful, is, and I think we already agreed to this, she doesn't want to be reported or managed by individual board members. She wants to help with, work with the whole board.
Mhm.
And she's really, doesn't want to be micromanaged on day-to-day decisions and have a little bit of that autonomy.
Yeah, so I mean, I'm glad we're aligned on really the vision that we want for Ascendia and for Dr. Morgan. So I guess,
I did want to talk a little bit about the condition of severance that you mentioned earlier. So we're totally willing to, sign a release as a condition of severance as long as it's appropriately scoped. We understand that Ascendia needs protection from post-termination employment litigation, so just wanted to make that clear.
yeah. I mean, yeah, it's just basically on severance, we need to release those claims, before we have severance. So, yeah, I think we
As
would.
long as it's reasonably scoped, and we can talk a little bit about that more when we
Mhm.
fully flesh out and write the contract.
Yeah, definitely. As far as this point, I mean, also we really wanted to talk about good reason. I know we mentioned it
Yeah.
earlier. So what does good reason look like for your side?
Yeah, so, for us, in terms of good reason would protect against constructive termination. So, some triggers would be salary reduction, less than 10% without consent, material reduction in authority slash duties or responsibilities, required relocation. Dr. Rhodes does not want to relocate. And, we can talk more about the days that she will have to be in the Miami office, and we're totally
Mhm.
okay with her coming in as needed once, we set some days and we're even a little bit more flexible on those days when things like there's a peak, like a lot of board meetings or if there's a M&A or
Mhm.
just a large contract going on. So we would also see that as like material breach of agreement by you all, unpaid salary, violated equity. We are looking for written notice within 60 days, 30 days to cure, and then her resigning within 30 days after cure period if it's not fixed.
Okay. Yeah, I think that works out for us. And then as far as here, I think another question I would have is, would Dr. Morgan be open to an at-will term? And then if not, would she agree to a 1-year initial term with certain outs? And then
Yeah.
a potential 3-year renewal if we have board
Mhm.
approval?
Yeah, she would definitely agree to an at-will term.
Okay.
She would not agree to a board renewal. At-will is fine just because we know it's standard.
Mhm.
We know there has to be, 12 month severance without good cause, but we think that the board renewal again creates kind of that unfair relationship where it feels like she's constantly auditioning for the role and not really leading in the role, and it's not really market standard for CEO role. So we would feel really strongly against that.
Okay. So yeah, I mean, I think we could talk like lastly is just like a severance cap. Um, if she would agree to a 3-month severance cap, unless termination follows a merger acquisition.
Yeah, I mean, obviously completely different situation if it's M&A, but
Mm.
we do think 3 months is not enough. It takes kind of 6 to 12 months to find a comparable CEO role, especially because these roles are not, just like your standard typical Indeed job listing. So we
Mhm.
would say the market standard is more 9 to 18 months. We would be okay with 12 months. We know 18 months is a bit of a lot, but we would say about 12 months.
Okay. Yeah, I think we could definitely negotiate on that term, and I understand your position as well. And then, I mean, yeah, I think we can move on to our next set of questions.
Okay, perfect.
Pretty okay with this side.
Yeah, I'm totally okay with, the things that we've talked about. Do we want to talk a little bit about like restrictive co covenants, so non-compete and non-solicit?
Yeah,
Um,
yeah, yeah.
I know that we can talk a little bit about non-competes. I know we still have to decide on choice of law and choice of forum. I think
Mhm.
from our prior discussions, it seems like we are okay with Florida, but we can chat a little bit more about that if we need to.
Definitely. Yeah.
So, what are your primary competitive concerns and who do you all see as direct competitors?
Yeah, so as you know, we're operating in the AI-driven wellness technology industry and also in digital therapeutics. So really, we want it covering companies competing with our Mindframe product and any related neurotech or wellness tools is really what we want to be covered.
Okay, perfect. That makes perfect sense. And what client relationships or employee relationships are you all most concerned about protecting?
So we're really concerned about protecting our business client relationships and any key product talent. So yeah, as far as the non-solicitor, non-compete, it should prohibit any of those employees, direct or indirect poaching for 12 months, really is what we're looking at.
Okay.
Hmm.
And then let me see what else I had questions for. We can talk a little bit more about the non-compete once, you start asking me what Dr. Rhodes is looking for. I think we might have a difference in that, but we can definitely chat a little bit more about that.
Okay.
Would you all be open to garden leave compensation if you want a longer non-compete than us?
I mean, our proposal holds at the 12 months, but we don't really see a need to extend the term with garden leave. But yeah, I think it's just adding a cost that we could avoid. Uh,
Okay, so for us, and I can just go in a little bit about what Dr. Rhodes is looking for in a non-compete.
mhm.
She's definitely looking at 6 months. 9 months is fine, but she would, ask for that garden leave if possible.
Okay. I think really what we're looking at is a 12-month non-compete. I mean, it's really something mm, we have to have like 12 months non-compete post-employment because just looking at our industry, it really is like confidential information that we want to protect for our Mindframe product. We're really just starting global expansion and we just raised a lot of funding. So really we want to extend a little longer just so we ensure that our talent isn't poached, especially with all the drive that we've been having recently. I think it's more than fair.
Yeah, that makes perfect sense. And we can talk a little bit more about IP, etc. later. And we obviously know that, Dr. Rhodes also wants her IP to be protected, so we can chat a little bit more about that. But I think once we chat about that, we can go back to this. But I'm good with settling on nine if you are on 9 months.
Yeah, I agree. I
Okay.
think that works out for both of us.
Okay, perfect. And did we want to talk a little bit more about like what our governing jurisdiction is going to be? I don't know. I'm sure you'll have some questions for me.
Yes, definitely. So I guess just talking about governing law. So would Dr. Morgan accept Florida as the governing jurisdiction?
Yeah, we're totally okay with Florida. As the governing both the choice of law and
Okay.
forum, we would greatly prefer Florida. That's, where Dr. Rhodes is pretty much has a heavy hand in, so we're okay with Florida.
Okay. Yeah, I mean, definitely we'll talk about that a little more later as well, I think. But as far as liquidated damages, is she open to them if she breaches these non-solicit terms?
It would really depend. She would, it can't be a punitive penalty. We know that Florida courts really scrutinize these provisions if, we're looking for to go into Florida. Um, she would prefer injunctive relief. So, very standard remedy for covenant provision. A court can order her to stop violation her like a violation, and we just think it's a little more appropriate than predetermined damages. And then if there is a need to either go into arbitration or litigation, then, we can go a little bit more into what damages would look like.
Okay. And then as far as, I guess, let's say she was accepting any new role within the wellness or neurotech industry, would she agree to notify Ascendia of this?
Yeah, she's totally okay with that.
Okay. And then also, can we clarify that non-compete covers advisory and consulting roles, not just formal employment?
Yeah, that's standard, and we totally accept that.
Okay. Yeah, so I think we're good to move on to our next topic.
Okay, perfect. So what, sorry, can we talk a little bit about intellectual property?
Yeah.
What IP would, Ascendia consider like core to its business?
Okay, really, we would include just any algorithms, codes, models, product design, or inventions related to our Mindframe product, because this is really what our company is banking on, or where we got all these investors from, and just
Mhm.
any associated platforms to Mindframe. So yeah, really, any all employment created IP, we need assigned to Ascendia.
Okay, yeah, we're totally okay with that. We're totally fine with anything that she creates within Ascendia, but really, anything that she creates outside the scope of Ascendia, any personal projects, any inventions unrelated to Ascendia business. As you know, Dr. Rhodes has a PhD, so she does sometimes do academic research at major institutions. So, like any academic research done independently, that would be her own IP as well as any future inventions and really anything that she created pre-Ascendia.
Right.
So,
Yeah,
if you
I think we could definitely find like a middle ground of what
Okay. Yeah.
exactly
If you all
major employment
are
means.
okay with that, we're totally okay with anything that she, creates within the framework of her employment at Ascendia.
Right. Okay.
Okay, perfect. Um, do you do you all have any, standard confidentiality? We just want to make sure that that agreement is consistent with any prior NDAs.
Yeah, so our confidentiality agreement will control and we'll cross-reference it in the employment agreement. So we ensure that it's consistent with any prior NDAs. And really, we do this at onboarding to prevent any later disputes. So we maintain consistent NDAs and intellectual property provisions through all our documents just to paper the IP chain and prevent any later claims. So we can resolve any disputes now rather than later.
Okay, yeah, we're totally okay with that. And just for the IP, I just wanted to make it clear she doesn't want to, just so we have it, before we move on a little bit, she wants to make sure that she's not assigning any future inventions to Ascendia, just the things within the scope of her employment.
Okay. Yeah. Yeah. I mean, as long as we really talk about like what is the scope of employment later on in the contract, I
Okay,
mean,
yeah.
really
So
up
we're
to we un
we're
we understand obviously.
yeah,
But,
we're totally okay with that.
um, yeah. I mean, are there any other questions you would like to ask or?
Um, I would like to go back to the non-compete later just because Dr. Rhodes did just let me know what exactly her standard for that would be. I don't know if we want to talk about that right now or we could talk about it later.
Yeah. I mean, however you like.
Yeah, so I would, we said 9, but it's that is looking to be too short for her. I think we would have to do a 6 months maximum.
Okay. I mean, I think if anything, we can negotiate that a little more later. But I mean, I think 6 could be pretty standard for us. I mean, really, we do trust that she's going to stay here for a long time, and I mean, the biotech industry is just really defining what competition is more important to us. So, I mean, if we concede on that point, we could definitely concede on competitors.
Okay, yeah, we're
As long as we
totally
negotiate a little bit on that, what defines competitors, have it a little broader, I guess. So,
Yeah, we're totally fine with that, and we're willing to make it the 6 months, maximum if we broaden up our definition of competitors. We're totally fine with that.
okay, awesome.
Okay, perfect. And then let me see if we have a little bit anything about if I have anything left about, intellectual property. I did want to ask, if Dr. Rhodes wants to write a book, do speaking engagements or consult on non-competing topics. Are you all okay with that?
Um, yeah, we're sorry. I have a free Zoom subscription. It says it's gonna end in 10 minutes. I think.
Okay, perfect. Do you want to hop off at 11:10 and then we can do
Yeah, and
the
then we'll just start.
we'll
Yeah,
hop
I
on
guess when
and
it ends, we'll just
okay, perfect. We can hop on any link.
um so yeah, as far as writing a book, we're supportive of it as long as she has prior written approval from the board and as long as there's no conflict of interest or misuse of confidential information or any brand risk that the board would see fit, then yeah, we're totally okay with that.
Okay, yeah, perfect. Is there any questions you have for me in regards to the IP?
Yeah, so just so we're clear on what IP is pre-existing prior to employment with Ascendia, would she be able to provide a written schedule of pre-existing IP prior to execution?
Yeah, she can definitely provide a written description, not technical details because of the NDA, but we're good with a general description of the two proprietary algorithms, any data developed, general field application, and just an attestation that they predate the Ascendia employment.
Okay, awesome. And then as far as would she agree that any modifications or derivative works developed at Ascendia belong to the company?
Yeah, like we said before, if it's created with Ascendia's resources or for Ascendia's basis, if it's created independently, like at an academic institution, then that would be her own. But you all will own any modifications using your time, resources, any modifications for Mindframe or Ascendia business purposes, and then she would retain independent modifications, academic research. So yeah, just her personal work would be hers, and then any work for Ascendia is y'all's.
Okay. And then do you think we could ensure that Ascendia retains a perpetual license to any pre-employment IP that's used within the company systems?
Within the company systems, is fine. We're fine with within the company systems. We don't really expect that that will be used, but if if pre-existing algorithms aren't related to the mainframe technology, then yeah, we're okay with that.
Okay. And then I guess I mean we talked about books and talks, having pre-clearance for competitive risk. Um, as far as an IP assignment clause, can we have it covering all future inventions regardless of patent filing?
Um, they would have to be specifically developed in the course of employment.
Okay.
So we don't want to, assign any all future investments to Sendia, but if they were just developed within the course of employment, then we're okay with that.
Okay. And then yeah, I
Yeah.
think we're good to move on to
Yeah. Okay. Perfect. Do you want to talk a little about work and location? Do we want to maybe end this Zoom and then start a new one just so we
or if
feel
you want, I could if you just give me a minute. Is there a
okay.
way to pause the recording and then start? Is it this?
Yeah. Yeah, you can pause it on top.
Pause it on top. Okay, yeah, so if we just want to continue on to the next topic and just got this done.
Um, so yeah, for work arrangement, what does regular presence in Miami mean to you all in terms of practical terms?
Yeah, so I mean that's a good question because we do want to quantify exactly what regular presence is. For us, it's at least 10 working days per month in Miami with attendance at the board meetings and any key leadership sessions. So yeah, at least 10 working days.
Yeah, we're totally okay with 10 to even 12 months. 12 no, months, 12 days per month is acceptable. And we're also willing to do 12 to 15 days when needed. So, for like board meetings, investor visits, major events.
Mhm.
Um, but I would want to talk a little bit about what the, traveling and lodging reimbursements would be.
Okay, yeah, so we could cover travel and accommodations for these visits to Miami pursuant to our policy. And as long as they're in within the pre-approved board budgets, then we're totally fine with covering that.
Okay, yeah, we would, we're good with that. She would like business class for flights that are greater than 3 hours, which is pretty standard for executives. She's okay for pre-approval if she needs to take unusually expensive travel, like an international flight. And then we're good with the annual travel budget within a reasonable threshold.
Okay. I mean, do you have any other questions?
I would say the only thing we would need is, no pre-approval for routine Miami travel. So like if she needs to come into the office one day, obviously totally okay when it's board of directors meeting, if it's a big um, if we're doing M&A, something like that, but she just doesn't really want to be micromanaged. So,
Yeah.
she just feels like she should be free to come into office as needed.
Yeah, completely understand. And then I guess as far as us, really, some extra things we want to touch on is just would she agree to these periodic in-person board meetings? That really is why we want her to be in Miami at least 10 days.
Yeah, she's totally okay with like in-person board meetings, product milestones, enterprise client events, annual planning. She's totally okay with that.
Okay. And then if can we track presence via an executive calendar metrics to ensure that there's transparency between the board, especially if Dr. Morgan is now joining the board instantly?
Yeah, like I said, she's okay with that. She's okay with transparency. We would say kind of no to, any like micromanagement tracking. So we would like a shared calendar. We're good with the shared calendar where showing when she's in Miami and when she's remote, monthly summary showing days in office versus remote, and then board visibility and presence patterns. We would not accept like a really detailed hour tracking of hours or attendance. Kind of I think of the way that lawyers do billing. But she's not okay with like badge swipes or login monitoring or requiring justification for remote days. But I mean, I don't think that would be with what we just chatted about. So, but
Mhm.
we're totally okay with like a shared calendar with the board showing when she's there and just a monthly summary.
Awesome. Sounds good. Yeah, I think we can move on to the next topic now.
Okay. Sounds good. And then do we want to talk a little bit about duties and reporting structure?
Yeah.
So could you clarify the reporting line? Does the CEO report or well, we actually already chatted about that, so I already had that question in, but let me see what else I had here. Yeah, I think we actually talked about a lot of the questions earlier that I had. What would be, okay, so I know we talked a little bit about the contractual threshold if we were doing, like a certain contract that's over, let's say, $1 million. I know that M&A is very standard, board approval needed for the industry, but what would be the approval process for hiring C-suite executive, or budget decisions? And then if we could really set a threshold for that major contract.
Yeah, I mean, I think as far as the major contract threshold, we could look a little more when we're talking the actual agreement, but I think 1 million would be a good number to have. As far as hiring C-suite executives, we do want Dr. Morgan to have the authority to employ what she needs, but for C-suite, we do need board approvals, just because the C-suite is the highest department of the corporation, and we want to ensure that they're in line with the vision of the board. Yeah.
Oh yeah, we're totally okay with that. Um, Is there any concerns about Dr. Rhodes' leadership style or approach that you would want to discuss right now?
Yeah, so really we've been looking at her credentials, obviously in the biotech space, and she's been a big player in this field. But really just one thing we want to harp on is we want to maintain Ascendia's innovative spirit. So we are a fast-growing company. We just got Series A funding. We really want to grow this thing globally. And so as long as we evaluate her leadership against our goals, I think we're completely fine with how this thing is going to go along.
Oh yeah, that's perfect. Do you have any questions that you want to ask me a little bit about that?
Yeah, so as far as my questions, yeah, I think we've touched on a lot of these topics already. Let me see
Hmm.
if I have
Yeah.
any other ones that I'm missing. So yeah, as we clarified, the reporting line, the CEO is exclusively to the board, only to the
Okay.
board,
Perfect.
and not to
Yeah.
any specific member. So there's not that concern there. Um, yeah, I think we agree on everything. I mean, would she agree to annual performance reviews tied to renewal?
Yeah, like I said before, we are totally okay with annual performance reviews, tied to renew of her employment. The only thing that we would not be okay with is tied to her board seat.
Okay, okay. Yeah, so I think we're completely fine with it. I mean, we've touched on a lot of topics I want to talk about, of the board overrides of major strategic disagreements or any board approval.
I
So
think
I
I'm
think we
okay with
can,
everything we chatted about. If we want to talk a little about bonuses and benefits.
yeah.
So I just want to ask you a little bit of questions about like how bonuses are structured within the company. So how are bonuses structured? Is there a target percentage of base?
Yeah, so we could definitely talk about a target percentage of the base and cap that there. But really what we want is bonuses at the sole discretion of the compensation committee. And then we want to tie it to performance indicators set by the board. Um, so we want to avoid just any automatic guarantees, but do want to set some outlines for you so it's not totally ambiguous as to what constitutes a bonus.
Okay, yeah, we're totally, okay with some guidelines that kind of show what the bonus looks like. She would ask for to not have a clause that limits at least the upside on performance-based bonuses. Um, so, you know, if you like, she's okay with bonuses kind of being discretionary and evaluated based on her performance, but we would ask that there's not a limit on performance-based bonuses.
Okay. Yeah, that's completely fine. I mean, as long as she performs, we're completely fine with that. And
Okay,
it's going to be
perfect.
set by the board, so I don't think we should have too much concerns with that.
Perfect. And yeah, you answered my next question, really what determines, bonus payout and what specific metrics would the bonus be tied to, like revenue, fundraising, product milestone? How would we define target versus actual performance?
So yeah, I mean, the bonus will definitely be tied to the revenue growth and any fundraising goals
Got it.
that we would have, as well as regulatory readiness, business client milestones. So we really want to tie this upside to actual results. So there's no ambiguity between both of us. And you said between target and actual performance.
Yeah. Mhm.
So target performance would really be the board approved goal set at the beginning of the year. And
Mhm.
then we could have it in an exhibit to the employment agreement. And then the actual would be the actual verified year-end outcome. And then we can compare those two outcomes to really see where we're at with the bonuses.
Got it. Yeah, that's perfect for us. And I just wanted to ask you what benefits are standard for executives, so like health, 401k, one match, etc.
So yeah, we at Ascending, we offer the standard executive benefits package, just
Mhm.
like other Series A stage companies. So medical, dental, vision, and then we also provide the standard paid vacation under our standard policy. Any executive perks like relocation, security dues, dues for membership, or tax prep would have to be board approved.
Okay.
We could include some minimum guarantees just so there's clarity between us two.
Okay, so in terms of the vacation, after, Dr. Rhodes is looking for after 3 years of, being in within service and being within the employment agreement and CEO, if she would be able to have an eligibility for a 3-month paid sabbatical.
Okay, as far as sabbatical, I don't think we would be able to guarantee that. So it really is just we're providing just standard vacation, and like I say, we are giving executive perks like relocation and tax prep and security. So we really don't see the need for sabbatical.
Totally understand. Would you all be okay with potentially instead of doing a sabbatical, doing 7,500 dollars a year for physical, mental, and spiritual health expenses?
I mean, if we could bring that down to 5,000 a year, I think we could get on board with that.
Yeah, we're good with that. That's perfect.
All right, yeah, I think we're good there.
Do you have any other questions for me in terms of bonus or policy, or would you, want to move on a little bit to choice of law, which I know we talked about earlier?
Yeah, I mean, we went over a lot of questions that I had as well. Let me just see if there's anything else
Got it.
I'm missing. And then I guess the only thing really I would have to ask is would Dr. Martin accept that bonuses do not vest if she resigns before the year end?
So, we know that standard practice is prorate bonus upon termination without cost. So if Dr. Rhodes resigned voluntarily, no bonus is expected. But if she is terminated without cause after achieving her targets, then she would receive want to receive proportional payment.
Okay, completely understandable. And then, yeah, I think we're ready to move on to the next topic. But just before, could I
Yeah.
pause the recording real quick just to charge my laptop, just so it doesn't die
Of
on?
course. Yes, go ahead.
Okay, we're back.
So, do we want to talk a little bit about choice of law and forum selection?
Yeah, I think that's a great topic to continue on.
So, what would your preference be on governing law? What do we want to do? I know we talked about Florida. I know Delaware is often a neutral place for a lot
Mhm.
of businesses, corporations. What about forum for disputes?
I think Florida law and Florida forum for disputes, obviously we're a Florida-based company. Our legal team knows Florida law. They're familiar with Florida law, so I think it just makes the most sense to have enforceable these covenants that we have in these agreements.
We're totally okay with Florida law as governing law for the contract interpretation, but we would like to be not have Florida as a venue for all disputes. Just we know federal law is, pretty standard in executive agreements and protects both parties' rights. So we would prefer to have federal courts.
Okay. Yeah, I mean, I think we're
Florida federal courts, we're totally okay with that.
yeah, I think Florida federal courts is a good meeting ground.
Okay, perfect. Would you all prefer arbitration or litigation for employment disputes?
So that's a good question. So for employment disputes, we're open to arbitration in Florida just
Mm-hmm.
to preserve confidentiality because we obviously want to keep disputes private and efficient between us. We are a growing business. But then as long as we could have a court carve out for injunctive relief, I think we're totally fine with that.
Yeah, we're okay with a court card cut out for injunctive relief.
Mhm.
We wouldn't, Dr. Rhodes wouldn't want to waive her rights to litigate based on discrimination or retaliation, but anything else, we're fine with arbitration.
Yeah, we're good with those carve outs as well.
Okay, perfect. And what provisions do you all see surviving termination of the agreement?
Yeah, so really
Clear.
confidentiality,
Mhm.
IP assignment clauses, and then restrictive covenants and the non-disparagement that we also want to have survive termination for 24 months
Okay.
is really what we're looking for to survive termination of the agreement.
Okay, yeah, we're totally okay with that.
And also, I need payment related provisions, just
Yeah,
obviously
we're good. We're good with
continue past termination.
that. We're totally good with that.
Okay.
Um, Okay, and then could we just explicitly state that non-disparagement, confidentiality, and IPality provisions would survive termination for 24 months at least?
Yeah, so the non-disparagement and confidentiality, we would,
Yeah, confidentiality and IP could survive indefinitely because we know
yeah,
that's industry standard.
yeah, those indefinitely, and then non-disparagement at least 24 months.
Yeah,
We would want standard.
we're good with that. Um, and I mean, I think that's it for choice of law and forum selection and survival. Do we want to talk a little bit more about just general boilerplate and anything else?
Yeah, I think we're good to move on, honestly.
Great. Are there any agreements that Dr. Rhodes would be signing, equity plan documents, confidentiality, invention? I know we already talked about confidentiality a little bit and equity plan, but I just wanted to make it really explicit.
Yeah, yeah. So, I mean, what were the ones you mentioned?
I mentioned equity plan documents, confidentiality agreements, and then invention assignment agreements.
Yeah, so definitely we'll have all three of those agreements. So equity plan for sure, confidentiality, and obviously we want the inventions assigned to Ascendia. So yeah, we'll have all agreements and we'll make sure they're all in conjunction with the employment agreement. So
Okay, great. Just
those,
wanted to make sure so I can have that down in my notes so that we can start drafting those on our side as well.
yeah.
And then how do you all want to ensure consistency across all these documents?
Yeah, so the employment agreement is going to cross-reference and control for conflicts between any of the agreements. So it just reads as a cohesive set. So we're going to bundle and harmonize all the documents up front so we don't have any gaps later on that could create conflicts.
Great. And then what's the timeline for finalizing the equity plan participation documents?
Right. So we're ready to move on an expedited timeline just so we have all the documents executing at the same time. Uh,
Mhm.
so yeah, I mean, we'll fast track all the documents so we execute them concurrently.
Okay, and then can Dr. Rhodes confirm that, or sorry, I actually don't think I have any more questions for you in terms of general or boilerplate. I don't know if you have any more questions for me.
Okay. Yeah. I guess. Would Dr. Rhodes agree to a single consolidated effective date just to avoid gaps between the offer here with the employment agreement and the equity plan?
Yes, a single effective date works for both of us, and I think it creates more clean documents. I did want to say for the accelerate agreement, so the NDA, the IP assignment, the equity plan, her, saying that she's going to execute all those before the start date, we're totally okay with that. We just want to make sure that we work together on those documents and we review all documents together in advance.
Right, right, definitely. I mean, we're all about transparency here, so
Okay,
we're
perfect.
on page there.
Is there anything else that you want to talk about?
Yeah, I think really we want to have like a warranty here. I just wanted to make sure we have it clear before we do the employment agreement, just so there's no surprises. A warranty that no other obligations conflict with this employment. We know she's a big player in this biotech space, so we just want to ensure that before we enter into this agreement.
Yeah, we're totally good with that. That's pretty standard and acceptable, so we're good with that.
Okay. And then as far as amendments, can we make sure that they require written board approval?
Yeah, that's completely standard. We're good with that.
Okay. Yeah, I mean, I think I'm good on all our parts of the discussion.
Yeah,
And I'll
I
keep
think
it.
I just want to, do a little quick check and make sure that I'm all good.
Mhm.
Um, yeah, I think the only other t thing that Dr. Rhodes would want is just tech stack choice within her job. So, discretion to select core productivity platforms, whether that's CRM, performance dashboards. Um, that's the only other thing that I think she would want.
Yeah, I think that's good. I mean, let me make sure.
Okay. Go ahead. You can take a second.
I mean, we also just want to make sure from our side that we're not going to indemnify Dr. Morgan for any
Mhm. Yes.
regulatory
So
fines.
you brought that up. Yeah. We're perfect with that. Yeah, we definitely would not want indemnification.
And then we also want to make sure that we talked about M&A deals without board approval.
Yeah, we're
Also,
good.
just using the internal systems and cybersecurity protocols, just so we're ensuring protection of our mainframe
Yeah,
product.
we're totally okay with that. That's also kind of part of the indemnification. So we want to make sure that she's
Right.
protected on all fronts and that you all are protected on all fronts as well.
Yeah. And I mean, I think yeah, we went over everything else that we needed to talk about, so I'm good here.
Well, great. Yeah, we'll have that employment agreement drafted within the next couple of days and we can chat about that. But yeah, I think she's, like I said, super excited to work with you all. She's been, like you said, a big player in the tech space for a long time. So she's really excited for this, where this is going to lead us.
Yeah, we're absolutely excited as well. So we'll get this done in the next couple of days. It was good talking to
Great.
you, Ariane. Have a good one.
Thank you. Bye, Anthony.